Hey guys, let's look at some of the details about the Pitt versus Jolie lawsuit on the winery, including covering some of the points that were made about my video yesterday, both about the legal posture of the case and also the abuse allegations that Jolie made that are part of the case now. So first, let's look at a little bit more detail of what we're talking about. So they purchased some time ago a winery called Miraval. That is in France. And then that winery is owned 100% by a company in Luxembourg called Quimicum. I don't know why, but that's what it's called. It's a company in Luxembourg owning the winery that's in France. The company in Luxembourg is owned by two companies that are United States companies, California. Mondo Bongo, and that's owned by Pitt, and Nouvelle, which is owned by Jolie. So there's quite a structure there. There's the actual thing itself, and then that's owned by a first-tier holding company in Luxembourg, which is held by second-tier holding companies in the United States, which are then owned by the parties of interest, Pitt and Jolie. So originally, this split was 60-40 in favor of Pitt, but in 2013, they executed an agreement where Mondo Bongo gave 10% of its shares over to Nouvelle for $1. And yeah, we'll get into that a little bit, but that's how they got to 50-50. So there's the structure of the thing. It's a beautiful winery, and not surprised it's held in complicated ways that has lots of times to do with taxes and other things. So who knows? Doesn't really matter for purposes of why they did it for the lawsuit as much as it matters of how it affects the lawsuit and their intentions in regard to each other for the lawsuit. So the lawsuit is essentially over the issue that Jolie sold her interest in her holding company, Nouvelle. So she's in America. She sells her ownership interest in an American company, Nouvelle, to another company. And now that company owns Nouvelle, which still owns the 50% of Quimicum, which still owns this winery. So that puts Pitt in a position of operating a company with a new entity that he doesn't like. He doesn't like the people behind it. He doesn't agree with what they want to do. They don't like what he wants to do. There is big disagreements there. So it is an unfortunate situation. And I guess to some degree, that's what brought this lawsuit on, is because their business dealings with each other have been contentious, to put it mildly. So he has sued Jolie, etc. Nouvelle, which is now owned by this new entity and new people. They've countersued him. Jolie has filed a cross-claim, like I talked about yesterday, asking for declaratory judgment. There is litigation in Europe over this, in Luxembourg, and there's anticipated litigation in France. So we'll touch on that a little bit, but there's a lot of things going on, all stemming from the fact that that these two people wanted to own this winery together, and then their relationship broke down, and they have to figure out how to split it up. It wouldn't be this complicated if they weren't so rich, but they are, and therefore that attracts like a light outside, moth to a flame, that sort of thing. Lawyers and accountants will come to this, and there will be controversies. It doesn't really make any difference what the documents say. If the people are willing to have controversies, there are people who are willing to fight them on their behalf, and that's the case here. So let's look at some of the quality arguments that were made about this lawsuit and see how they stack up. Smoking gun number one, the documents related to Quimicum, the articles, say in 5.4.3 that you cannot transfer shares to a non-shareholder without the agreement of at least 75% of the existing shareholders. And since they were 50-50, if Jolie did not have the consent of Pitt, then she can't transfer shares to a non-shareholder. And that's definitely true if Jolie were the shareholder. But the shareholder is Nouvelle and Mondo Bongo. Those are holding companies. They're entities. They were set up by both of these parties. That's the shareholders, okay? So she didn't sell any shares in Quimicum. In fact, she didn't personally own them. She owned a membership interest in Nouvelle, and that's what she sold. Now, the smoking gun people will say, yeah, but that's right there in the contract, bro. It's black and white. It's right there. You didn't look at the articles. You don't understand what the situation is. Maybe not, but it should be easy to figure out, because I'll simply go to Brad Pitt's lawsuit. His lawyers know as much as we do. They should know more, right? They've examined this. And if those articles apply directly to this situation, got a clear breach of contract. You can't do that. You signed on to this and you tried to sell shares that you didn't have the right to sell. This contract controls how we sell shares. The first claim in the lawsuit will be breach of contract. So let's check it out. All right, I got the first page of the lawsuit here. Let's just look for that breach of contract claim and set this stuff to rest. If she breached it, she breached it. First claim, breach of implied in fact contract. Implied in fact contract is not a written contract, so that's okay. They're not referring to it in this first cause of action. They're referring to something else, an implied in fact contract. So by behavior, course of dealing, something like that, that could exist too, right? We haven't gotten to the smoking gun aspect of this yet. Second, breach of quasi-contract pleaded in the alternative. A quasi-contract, well, that's not this sophisticated actual contract that exists controlling the Quimican shares, right? So that's not it either. Claim 3, breach of implied covenant of good faith and fair dealing. Yeah, okay, well, if you did that, that's bad, but that's not a direct breach of a contract. That's just not dealing fair. But that's not straight breach of contract. Abuse of rights under Luxembourg's Civil Code. 5 and 6, tortious interference with contractual relations. You're starting to run out. Tortious interference with prospective business relations and constructive trust, which means not a real trust, but one that could arise by operational law. Did they forget to put it in here? The most basic claim, legal claim of all, breach of contract, just straight breach of contract? I don't think so. I don't think they did. Now, they do have some good claims in here, but they do not have a direct claim that the contract itself, those articles, were directly violated. So is there more to this? Let's see who's weighed in. So on the defense side, they call in a legal expert, someone who was the former president of the Luxembourg Supreme Court and the Luxembourg Constitutional Court until 2021. That sounds like somebody doesn't know what they're talking about, right? Yeah, I got it. If you pay people, they're more likely to say what you want. But still, those are pretty substantial qualifications, okay? You could ignore it if you want to because he doesn't say what you like, but that's stupid because he has excellent qualifications. They would have to be rebutted by somebody else citing some pretty specific law. Let's see what he says about Luxembourg law, since it's a Quimican is a Luxembourg company, and I think the agreement calls for application of their law. So he cites something that's fairly similar to an American concept, which is there's no room for the court to interpret a contract unless it's vague, ambiguous, incoherent, contradicts, or something like that. They can't, under the guise of interpreting it, distort it by ignoring clear and concise meanings. So the articles contain an express restriction on the transfer of the Quimican only shares. They do not restrict the shares of downstream holding companies, such as Nouvelle, or prevent a change of control in Nouvelle, even though the notion of change of control is known to their legal system, like obviously it is here. Because the parties expressly address the topic of restrictions in the transfer of shares without imposing a restriction on the transfer of shares of Nouvelle, or Mondo Bongo for that same point, a judge would not be permitted to add such a restriction to the articles, even under implied or general obligations of good faith. He cites again the general law, which is for his country, which is that the law provides certain rights only in the event that a shareholder proposes to transfer shares in the Luxembourg corporation, and it's not triggered by a change of control over a shareholder in that corporation. I'm aware of no scholarly work or case law suggesting that the article provides any rights to shareholders in the event that a shareholder of the corporation undergoes a change of control, and plaintiffs do not cite any. So remember, I showed in the video yesterday that there was a discussion from Jolie's business agent to Pitt's business agent saying, hey, do we need to come up with something for the restriction and to control how this could be liquidated in the event it needs to be in the future. And they said, no, don't worry about it. We're reasonable people. We'll get along. And that unfortunately didn't work out. But it was a known concept and a known potential gap there. So they didn't close it out here. And it matters that these are companies that are shareholding. They're not the individuals themselves. If you buy a Tesla, you're not forming a contract with Elon Musk. He's a shareholder. Okay, he has an ownership interest, but the entity is Tesla. And so the entity that owns Quimican is Nouvelle and Mondo Bongo. And then the entities that own them are Brad Pitt and Angelina Jolie, at least until she sold her interest. So that's a big problem, and it explains why his attorneys have not directly alleged a breach of contract in this lawsuit. It's not because there's a smoking gun and they haven't found it. It's because the gun isn't smoking, and they're trying to bring in other provisions in the law to say that even though it doesn't expressly control us through these other acts, actions, and general obligations of people, they should control us. It should control us, right? It should happen. The equity is on my side. And that can have a place in the law. I'm not saying it necessarily on the face of it that that's wrong. I am saying that the lack of a direct cause of action in the lawsuit for breach of contract is intentional, and it's because of the limits of how far they can push that document to control what happened downstream. And I'm certainly not anti-Brad Pitt here. I like the guy. And I think the story he tells in his lawsuit, and then he has told outside the lawsuit, that he was the one who was the driving force to improve this winery. It was really a passion for him. Apparently it still is. And he put additional money and effort and sweat equity into it. That is all very persuasive stuff. I believe all of it. It can explain to a large degree the emotion and attachment he has in this situation and why it has hurt him so much that it has come to this. So it is unfortunate, and it shouldn't have ended this way. Neither party, in my opinion, is fault-free in that process. Unfortunately, the ship has sailed a long way out, and it appears to have Titanic written on the side of it because they're all in these mega lawsuits. It's not looking too good. So all bad things, all good things come to an end. All bad things do too. So something will happen eventually. But for right now, it is a bad situation for Pitt, and I feel a bit bad for him on that. But back to the legal facts, okay, the things that the equity side, I get where he's coming from, but on the legal aspect, he has his problems. So first of all, he doesn't have a direct breach of contract claim, and his story doesn't really add up that this was all a hidden secret to him, that it came out of the blue, that she was going to sell this to somebody else. Because remember, she was proposing to sell it to him, and he was proposing to buy it from her. And I'll show here a letter from one of her representatives when they thought they had, or they did have, a concluded terms, major terms at least, the price, the things that surrounded that would matter, and it could be reduced to all the mumbo jumbo that you have to do. And then Pitt backed out, apparently, allegedly, due to being upset about some of the things that were going on the family law side of the case. So the representative is saying, hey, look, here are the terms we agreed to. Sorry, wrong way. Here are the terms we agreed to. We still want to do this, right? We're going to do this, right? So Pitt had the chance to buy the winery at $54.4 million, and with Jolie saying, I will not disparage the business in any way. So he could have taken full control over it. If he couldn't afford it, and I don't think that's the case, he could have also proposed to bring someone else in and work with him on it, or financing, or whatever he needed or wanted to do, he could do. But he didn't. He stalled on that. And according to Jolie's side, what he wanted was additional commitments from her, a broader non-disparagement clause that could have covered things that they were still arguing about outside of the winery. And apparently, I suppose, a greater impact on the holdback of the $8.5 million of what could cause her to forfeit that. So those things, as I said yesterday, they were not exciting to her team, and they didn't agree to those. And they ended up putting on the table to Pitt, look, if we can't go back to what we all agreed to and get this closed, I'm going to have to find another way to get out of this. I'm going to have to find another way to exit my ownership portion of this deal. Now, there's the red flag coming up right there. If we don't get this done, I'll find another way to do it. And either he thought he could stop her from doing it, or he just thought she would fold. Whatever, it didn't happen. And then, of course, she ended up making a sale for well in excess of $60 million. She got $12.5 million more from somebody else than she was willing to sell it for to Pitt. So you can be against her or against him or whatever, but that's a major breakdown there. That's a very unfortunate breakdown, because he could have got it, it looks like, for less than its commercial value from her, could have owned 100% of it, and this fight never would have happened. So that critical juncture there, and this shows sometimes where people being hard-headed, or if the advisors just can't get it together, although it looked like they did have advisors who were trying to do that at various times, both sides. You're this close, and then you don't quite get over the goal line, and this whole thing falls apart, and now you're in this lawsuit involving all these parties in multiple continents, costing who knows how much money, and it's just a terrible situation for everybody. it really would have been better if they could have closed this deal as they had originally contemplated it, both of them, with him buying her out. And they had that deal structured, and it did break down. All there is to say about it now is, can he force an unwinding? And I understand better after reading his side of the story why he would like to unwind it, because more than, say, punishing Jolie or something like that, I think he really doesn't want to be in business with these other people. I do feel like that's his primary motivation. I get that. And if he could cause a deal to be unwound, they wouldn't be in business with him. So that's a big deal to him, and it makes sense. Does he want to punish her too? Maybe so. I don't know. But I definitely understand now why he would like to have this transaction undone. He wants the shares really put back into her court. She would be the owner then. Now, if he wins all that, she's certainly under pressure, because then hypothetically, if she lost this case, she would need his consent to sell and this, that, or the other. And she, so that would be bad, right? So for her, it's not good, but this conflict is also not good. But I don't know that it's not in her hands anymore either, because she has sold her interest in her holding company. And those people are apparently willing to fight, because they've countersued in this case. They told a federal court in the United States that they were going to initiate litigation in France. There's a fight in Luxembourg. There's a lawsuit going on there. So anyway, we'll stop talking about the first tier share transfer restrictions, because we've shown it, we've gone over it. If it were a direct smoking gun, it would be alleged that way in the case. Instead, it's just used as a premise to try to find liability and the ability to have this transaction unwound as a footing for other claims, this implied in fact contract and all these other things. So it's not as smoking as his advocates would like to think. It's clear, but it isn't clear that it applies to the downstream holding companies that are in the United States instead of the Luxembourg company. That could have been the case. They could have made that happen. Certainly been in transactions where change of control provisions are involved when you have subordinate multi-tier holding companies, because this kind of thing can happen. But they didn't do it here. So that's, take that for what it's worth. If you're thinking about buying a winery in excess of $100 million, don't skimp on any documents that may matter down the line. That's general advice, not particular legal advice, but I think we can all agree with that from this case. Let's go down a little side alley here, which is this 10% of shares that Mondo Bongo gave over to Nouvelle 2013 for $1. That's a good deal, right? $1. So it's alleged in Pitt's lawsuit that he didn't get that $1. Now, is that going to matter? Well, it won't really matter in the United States, because that's not material to the lawsuit here in the particular claims he's filed. But apparently there is a lawsuit in Luxembourg where he's trying to make it an issue and saying that that should be unwound. Now, in February of this year, the federal court in the United States reports that the Luxembourg court declined the request to put the disputed shares, the 10%, into an escrow. I don't have the documents for that, and that doesn't signal a good thing for that lawsuit. But then again, I don't know how easy it would be to have a court force a thing like that over there. I mean, who knows, right? So the question is, this $1, is a nominal consideration like that enough to support a transaction like this? It clearly doesn't relate to the value of the shares, right? And then is the failure, if it's true, to pay the $1 material to whether you can still go get the $1 if you want, or can you just say, I don't want to have this 10% turned over because I never got the $1, so I'll just void out this contract? And the answers to those things depend a lot in the United States to some degree in which jurisdiction you're in here. And then, of course, in every country, you can have completely different answers. And it only affects this 10%, so I'm not tracking down Luxembourg law on that. I don't really know or care, but that's the issue going on there, as they're trying to say that provision was non-enforceable. Now, what is more interesting to the United States matter is the idea that one of the reasons he was willing to have his holding company transfer to her holding company 10% is because of the understanding that they had that she would never sell these shares to somebody else, or else why would he give the 10% to her for free? And that's logical. That is logical. Unfortunately, for his side, it does say in the agreement to hand over the 10% that neither party, and that includes him, relied on any representation, agreement, or any understanding that isn't captured inside of the written document. So if you're a gigantic fan of the written document for the articles for the first tier holding company, You can't just throw this out and go, well, that doesn't mean anything. Why not? Well, because it doesn't comport with how I'd like the case to end up, obviously. No, they both mean something. But unfortunately, in the first instance, the articles of the first tier company, it's disputed, and it looks like successfully so, that captures under a contractual basis the downstream member owners of the second tier LLCs. It doesn't look like it does that at all, or else he wouldn't have to make all this quasi contract and good faith dealing stuff. He wouldn't have to argue that. He could just argue breach of contract. And in the second case, can he say that this proves that that I had an understanding with her for the fact that she would never sell her shares and I wouldn't either without the consent of the other? It's not material to his contract there for the buck, okay? Because he wrote in there, and she did too, that nothing else outside of this agreement matters. You can't bring that stuff in here and bootstrap in a new obligation to somebody in this contract. That's why you have a provision like that. But I think it's fair to his overall narrative that that's what he believed. Now, whether his believing that and it's consistent with even what she put in her counterclaim, cross-claim, that he said that reasonable people can work through this. That is all consistent with him thinking, that we'll get through this together. And then he can say that's because we need each other. If we're going to, either one of us is going to get out of this, we both have to agree to that. That's his story, and I see why he is saying it. But the document, the $1 by itself, that doesn't prove that, and it's not supposed to prove it. And in fact, it says it doesn't prove it, because it says that nothing outside of this document relates to how and why these shares are being transferred over for $1. Because sometimes that, you don't capture all the consideration inside of a contract. Maybe you should, but you don't, because you don't want people to know it. So there could have been money headed back and forth in either direction, estate planning things, trust. You don't know any of that. And the document says that none of that stuff matters. Just look at what is in this document. So that's a big limit on that, although it is consistent with his narrative. So that's how it relates to the U.S. case, only really to me in terms of how it supports his narrative of what he believed, and not specifically in a direct legal sense. So the idea that you had sophisticated parties represented by lawyers all over the world who knew in one document to say we can't transfer the shares here, knew enough to say, hey, should we make a more express agreement about controlling the transfer of this asset in the future, and that he didn't do it, that they couldn't and shouldn't have, if they wanted it, created a contract between them that controlled them to control how the shares would, or membership interest in the second tier LLCs that each of them owned, how those could be sold. And if a change of control occurred in one, that would trigger the upstream share restrictions. That they could have easily have done that, and they didn't do it. And that puts him in a bad spot of saying, well, I just believed it based on things that, we thought about each other and how we behaved and that sort of thing. That's not where you want to be. That's not the strongest argument you could have. The strongest argument would be to have it in writing. And the fact that you didn't put it in writing is a strong argument for the other side, that we're not going to have an oral understanding over this $130 million asset when we had specific legal documents that delineated what all our restrictions were. And then on her equitable side of the story, she's saying, but despite all that, I did give him the first right to purchase this. I did give him a price that was lower than what third-party outsiders were willing to pay by a large degree, like a 20% discount on this asset, recognizing his commitment and other things to it. I gave him all that, and he backed out of it to try and pressure me over our general marital situation and settlement. He backed out of buying this asset and leaving me, after telling him that if we don't go through with this deal, I'm going to have to deal with it some other way, with dealing with it some other way. His equitable side is, but look who you sold it to, okay? So you sold it to, saying yesterday, the worst enemy. After reading it, I was maybe a little flippant on that. This may be his worst enemy, because they surely do not get along. So I can understand his ire on it. I can understand his motivation to file this lawsuit, because he doesn't want to be in business with these people. And also maybe he knew that a lawsuit was coming anyway. So be first if that's going to be the case, because they're definitely butting heads on this business. So I said it was dumb as to her, and I still have that opinion. However, it's not dumb in terms of his overall situation with a business that he poured his heart and soul into, stuck with people that he can't get along with. That sucks. And if he has any legal way to get an upper hand even if it's not directly going to impact Jolie, but just some other way to put these people in doubt and maybe cajole them to get out of the business. Maybe behind the scenes, eventually they work something out where he can purchase it from them or something, because otherwise, if they just fight each other and destroy the thing, there's nothing there for anybody to have anymore. So I don't know how this is going to work out. I get his motivations a little better after looking at it more deeply. So I appreciate the comments that alerted me to that. I still think her liability on this is extremely weak. And if that's all that were at stake, it would be not a worthwhile set of lawsuits to be involved in. So that leads now down to the final aspect of it, which was really kind of why I dipped my toe into it yesterday, was just about the part about her explaining the abuse allegation that she had and why the marriage folded up. And I explained yesterday her justification for having those allegations in the lawsuit. Whether you like it or not, that's her justification, is that it puts the context to why they split up and also puts the context to what it was that she says that he was trying to get her to not talk about as a new term in this deal on selling the winery. So that does get back to her not being an Amber Heard part of it, and some comments yesterday. I want to go over the logic of that. So in the outer circle of things, there's nuts, right? So there's the believe all women nuts, because that's stupid. That's just stupid, right? Women can lie just like anybody else can. Their perceptions can differ between women, men and women, all of that. So believe all women is really stupid. That's a slogan made maybe by somebody who isn't themselves stupid, but knows they're marketing to people who are stupid. So as I've said before, if you hear someone saying that, you know you're dealing with an idiot. Then there's also, on the other side of that, the He-Man Woman Haters Club that says that all Me Too things, and that they use the Me Too now to say all these women are lying, right? The corruption of some of the Me Too allegations mean that all of it's wrong. You could just lump them all together. You don't have to study any facts or understand anything. It's terrible what's happening to men now, that these women just lying and all the time. They can just, for reasonable people in the middle, the nuts can just, why don't you just go around all of us and just yell at each other, because you're idiots on either side of that, right? And then you move in the circle a little bit, and there's, hey, I'm not as extreme as that, but I think I know what happened on this because of this, that, or the other. And that's much better, right? Except that there's a flaw there, which is you don't know what happened. You weren't on the airplane. You don't have any idea what happened. You can have an opinion on it, a probability, that sort of thing, but you do not know. You don't know. I don't know. I don't know if she's telling the truth, or if she's telling the truth as she perceived it and it's not actually what happened. I don't know if she's intentionally lying or everything she says is the gospel. I don't know that. I know she was on the plane. I know that she says he was drunk and yelling. He says he was drunk and yelling. She says that led to contact between Brad Pitt and her and at least one of the children. He says that last part did not happen. So he gets 80% of the way there or whatever, and there's a disagreement over the last little bit. So we don't know. We know that she was motivated enough that shortly thereafter she filed for a divorce. So maybe she perceived it to be worse than it was, and then he did. They're in a small space, an aircraft. I have trouble automatically crediting a completely drunk person's version of every story, maybe sometimes. But if you're always taking the side of the drunken person, maybe you should consider your logic there a little bit, because drunk people are often not the most reliable narrators. And sometimes drunk people do things they wouldn't do otherwise when they're sober. I mean, am I the only person on the planet that is familiar with how alcoholism can affect the behavior of people? I mean, certainly not, right? So I think, to me, Brad Pitt strikes me as a really good guy. He has said he has tried to defeat his issue with alcohol, and it appears to me from what he said, he's been largely successful in that. I think that's a great thing. In that instance, being raged out like he was, did he make contact with somebody or not? I don't know the answer to that. I don't know if he knows the answer to that. That kind of depends on how drunk he was and maybe how honest he wants to be with himself, as much as it does whether Jolie's lying or not. And to me, to some degree, it doesn't matter, because he didn't end up, it's not like he broke somebody's arm or murdered somebody. He acted out somehow inappropriately by his own admission, and he's tried to deal with the problem. So unfortunately, their relationship didn't work out. However, the actual facts are, we just don't know those, right? And you can't say that you know it by other extrinsic things like, well, the FBI didn't put him in jail, so he's innocent. It didn't happen because the FBI didn't arrest him, bro. The FBI did check into it based on, I guess, a call that they got. They didn't end up arresting him, and apparently they did discuss it with the U.S. attorney, and they didn't take it any further than that, and they closed the case file. So does that mean he didn't do it? Of course, it doesn't mean that. It doesn't mean that at all. They constantly make decisions on whether they're going to proceed with something, whether it's significant enough or in the best interest of the parties involved. It also doesn't mean that he did do it. Just because they checked into it and wrote a report and took statements even from Jolie, who I think told them, that he hit her and this, that, and the other. That doesn't mean he did it. And it doesn't mean he did it even if they wrote it in his report. The FBI's decision to charge or not charge someone is not a definitive statement on guilt or innocence. So if you hate Trump and he wasn't charged during this whole Mueller thing, that just means he's totally innocent, right? I mean, you got to support Trump at this point, right? No. And if you like Trump and you see perhaps about to be charged, then you're going to go, well, yeah, I guess he's guilty because they're charged. You won't do that either, right? You have your conclusion first, and you're reaching back for things that support your narrative. Hunter Biden, they haven't charged him anything with years. They've known about the things he's done with the drugs, the money, the firearms and stuff. They never charged him, so he must be innocent. He hasn't done anything wrong to break the law. Why would you charge him now? Because you looked in it before and you never charged him. He must be innocent, right? Likewise, if he's charged, then his defenders will say, oh, look at these charges, that he's largely innocent of this, that, and the other. And he was on, so I agree with the people who say that whether someone is charged or not charged is not a decision by the agency, okay, that the person is completely innocent or completely guilty. Now, in theory, if they are charged, they got to have a probable cause for that. They got to believe, and the district attorney's got to generally believe that they have evidence or going to have the evidence that is substantial enough to lead to a conviction beyond that you're going to be able to convince the fact finder beyond a reasonable doubt that the person's guilty of the crime. So that can also frequently leave law enforcement believing we have the right person. Okay, we have evidence and we know we've got the right person, but it's too risky to charge or not worth our time because we don't think we can convince people beyond a reasonable doubt, even though we're pretty confident we got the right person. They can think that internally and make a decision based on that. I mean, in the Manson case that I've done other videos on, he was investigated by law enforcement. He hasn't been arrested. Does that mean he's innocent or guilty? It doesn't mean either one of those things. And people who are on his side talking about the FBI letter, when is Evan Rachel Wood going to be arrested for that? Probably she's not going to be arrested. And that doesn't mean that she did or didn't commit a crime in her involvement in that letter. It just doesn't speak to that. They have their priorities. They have the benefit to all the parties, including the potential victims, to consider when they do these things. So that's an overstated case there. But if it makes you feel better, if you feel like you know what happened on that aircraft, to say, well, he wasn't charged by federal authorities and put in jail for that, that means it didn't happen. You can think that. And in fact, maybe it didn't happen. But that fact by itself, that these other people reviewed it and didn't move forward with a charging decision, that doesn't lead to that conclusion. Okay, it just doesn't. Again, not saying Brad Pitt's a bad guy, or that even if everything she said happened on the airplane happened, that makes him evil or irredeemable or awful or anything like that. What it means to me is the same conclusion that he reached, which is whether he did those actual physical acts in addition to the other things, he had an issue with alcohol that he needed to be the kind of person he wanted to be. And I applaud him for that. So whether it happened or it didn't happen, I'm glad that he's trying to fix that. I really am. I hope this lawsuit works out eventually to some way that preserves the asset for him. He's put a lot into it. I don't know how that's going to work out. And mostly I hope that he and Jolie eventually can find some kind of path of resolution to be at peace with each other, because they do have kids together, a lot of history together. So that's all unfortunate. Anyway, that I hope addresses some of the things in the lawsuit to look at it a little bit more deeply, and also comment back on the abuse stuff. Thanks.